We'll hear argument first this morning in Case 11-564, Florida versus Jardines. Mr. Garr?
Thank you, Mr. Chief Justice, and may it please the Court. In the three prior cases in which this Court has held that a dog sniff is not a search, this Court has emphasized that a dog sniff is unique, both in terms of the manner in which information is obtained and the nature of the information revealed.
I mean, that just can't be a proposition that we can accept across the board.
Suppose the house had on the lawn, no dogs allowed.
Justice Ginsburg, first of all, I think there would be complied consent for that, too, at least as long as the dog was on the leash.
That's a huge assumption.
Well, you could certainly put the no dogs allowed sign up front, and there would not be implied consent.
But tell me why you presume that there's implied consent.
This search took place. A dog walked up the same way that a salesman would and alerted at the front of the door.
So we're going to treat it like a human being now? So now we tell dog dealers put up a sign that says no dogs?
Imagine that you have a home. You do expect people to come up and come into the house, knock on the door. Do you expect them to sit there for 5 to 15 minutes, not knocking on the door, doing nothing?
I think what happened
sniffing.
here.
Now, why is that unconstitutional?
Well,
would a homeowner resent someone coming with a large animal sitting in front of the front step on his property and sitting there sniffing for 5 to 15 minutes? Is that something that you invite people to do?
We've had a lot of discussion about whether it's 5 minutes or 15 minutes. So I understood the issue before us to be whether or not, under the Fourth Amendment, it is a search for a dog to come up to the door and sniff.